hold on one second. I'm just going to go to my YouTube studio. All right, I think what we'll do is update on Barry's court today, and then we'll go and read through the second part of the document dump there. So let me just get to our live stream. They're all good. Okay. All right, content, live. All right, here we go. Okay, so, hi, Deborah Van Couverden, 80s girl. You're listening? Okay, thank you. Michael, hello there. Anna Patty. You yelled out your car window? You could do it on Twitter too. It'd be a lot of easier than your car window. Aurora Rodriguez, thank you though. Nanette H, Nicole Griffith, York Hill, J.R. Snow Remover, High 61. Okay, I'm going to go get the updates from Lauren Scharf for court today because she covered that. Okay. Let me get from the beginning here. Okay, communication log. Trying to get to the beginning of this. So they have to update it in Twitter here, so I just want to get to the beginning. All right, so this is the one that where we were when we read the one tweet before we closed the last part one of the document read, where that Barry Morphew had just walked into the courtroom. The media and public were waiting in the hallway. The next update was that Eitan claims the FBI agent Kent Harris, Deputy DA Jeff Lindsay, and Commander Alex Walker allegedly intimidated witnesses in the Barry Morphew case. The judge denies the request to sequester the witnesses. The next update was that the defense is concerned about emails between law enforcement and witnesses being deleted after a certain amount of time, 90 days. Prosecution says they were not aware of the issue until yesterday and wants the defense to file a motion. The motion was filed 3 months ago and wasn't heard or changed, and I believe that we did read that about the emails. Okay. After the preliminary and the court ruled, Eitan said that they had issues with getting information in a timely manner. She said they learned that CBI agents had been communicating about the CODIS match and that they should have gotten that in the original discovery dump. Okay. This is a case of innocence. Mr. Morphew said from the beginning that she isn't gone because of me. Attorney Iris Eitan said. Okay, Iris is explaining what pieces of evidence they don't have. We aren't just asking for emails and text. This is Grady exculpatory information. There is a database where all of the agencies are communicating to this day, and we aren't being produced to the defense. Excuse me. It'd be better if I put my glasses on here. The next update was there is a black hole in this case, any evidence that points away from Mr. Morphew. The prosecution just objected. We have never perpetuated fraud upon this court. Okay, then they showed CBI agent Joseph Cahill walked into the Chaffee County Courthouse for the Barry Morphew hearing. Next, Lauren tweets, we have a list of things that they haven't produced. Email and text, all statements from all experts, the SmartForce database that they are all working to communicate on, HP laptops, Ritter's communication memo, and a camera that produces Faro scans. Eitan says that the only reason why they know that they don't have this discovery is because they have subpoenaed a CBI analyst. They plan to call 6 witnesses, including investigators and members of the DA office. The 11th Judicial District Attorney's Office is completely redoing the discovery, reorganizing it so it is easier to find information. The prosecution said they are hiring more people to help with the load of information in the discovery and will resend it as soon as it is complete. Iris I-10 is now showing a list of discoveries still not produced, reports, statements between the DA and law enforcement, opinions of experts regarding DNA matches, emails, text messages, district attorney to law enforcement interviews with lay witnesses that is exculpatory, HP laptop, etc. SmartForce database, sync meetings, report notes, version of the affidavit that reviewed and commented by Agent Cahill, never asked for it, communication regarding CCSO positioning, game camera near Morphew's home, and surveillance footage. Judge Murphy denied the quash Deputy DA Jeff Lindsay being subpoenaed, the former prosecutor of the Barry Morphew case. He is now appearing on WebEx. My apologies, it was the 4th Judicial District Attorney's Office who is helping the 11th Judicial District, Chaffee County, redo the discovery. The 4th Judicial DA covers Teller and El Paso counties in Colorado. The court is having technical difficulties getting the former 11th Judicial Deputy DA Jeff Lindsay on WebEx. Eitan is still on the podium, about to ask him questions. Lindsay sounds like he's underwater in the speakers. DA Lindsay will call back at 3:30 p.m. Ms. Megan Douge will talk about CODIS DNA issue. She takes the stand now. Eitan is asking her questions. She is an agent with the CBI. Agent Douge is a technical reviewer for a coworker. She takes notes when she speaks with law enforcement to keep a record of information related to the case. It is a communication log. Douge says to keep track of information of conversations that we've had. The exhibit entered into the court in the communication log. Eitan is asking about the first log that Agent Douge made on August 11, 2021. She was subpoenaed on August 9th to testify in the preliminary hearing. However, she did not. On August 11th, the conversation was with DDA Mark Herbert about CODIS keyboard search from the DNA swab from Suzanne Morphew's glove box. We discussed the difference between the keyboard search and the CODIS search. Douge is being asked questions about details discussed. Eitan said Douge's statements were not provided for the defense. She performed the keyboard search for the DNA swab from Suzanne Morphew's glove box. On September 2nd, Caitlin Rogers wrote this communication log about their work. Meeting will follow about what DNA has been tested and what hasn't. CODIS keyboard search included 3 sex offenders. Invest. We'll see if they were in Colorado at the time of Suzanne Morphew's disappearance. Agent Douge said that she told the defense counsel everything that she knew. She says when they were compiling info for the defense, it was revealed a letter for a match notification that usually comes from CBI was not handed to them. Prosecutors said there was a software glitch. Then there was a break. Back from the break, still having technical difficulties with former DDA Jeff Lindsay. He will have to come back and the subpoena will stay. CBI agent Caitlin Rogers is next on the stand. Caitlin Rogers is a forensic serologist for DNA analysis. She has authorized 9 DNA reports in the Suzanne Morphew case. She is not a CODIS administrator. She is not a CODIS caseworker user. She is a CODIS caseworker user. Agent Rogers takes notes and prints emails and puts them in the case file. She also writes a synopsis of the topics discussed in the communication log. Rogers is now reviewing the communication log, which was prepared November 2nd, 2021. The judge is asking for clarification because he is lost. That sounds good. As Eitan questions Rogers, I didn't get the truth from Agent Cahill about how much he knew about the DNA, Eitan said. What was in the communication log reflects differently from what law enforcement said about their knowledge of the DNA. Judge Patrick Murphy is trying to focus on why the defense has filed a motion for the discovery violation. Eitan says the large amounts of evidence that's been withheld from the defense should have been considered for his bond, making it less and might not have been bound over for trial. Rogers is now stepping down from the stand. The judge wanted the court to know that there was a lot of communication over the phone and once in person between Rogers and Cahill. CBI agent Joseph Cahill will now testify. CBI agent Cahill is here after being subpoenaed on November 4th. He was asked in an order by Eitan to preserve emails. Cahill said Cahill didn't give them any emails, according to Eitan. In the state system, after 90 days, the emails in a person's inbox get auto-deleted. If emails are in his spam folder, they get auto-deleted after 30 days, according to Cahill. His texts, he claims, are in a PDF file and are still on his phone. The SmartForce database is a data management sharing tool purchased by CBI to share documents across multiple agencies at the same time. Cahill said this was created specifically for the Suzanne Morphew case. They were trying to build digital casebooks for each agency. Ms. Eitan, I'd like something productive to come from this hearing. Judge Patrick Murphy said we are going to have to continue this hearing. Can we focus the questions for Agent Cahill, whether he wrote a report from information from Agent Rogers? On August 24th, 2021, preliminary hearing, do you want to change any of your testimony? Eitan asked Cahill. He said no. Eitan asked, did you write a report about the conversation you had with Agent Rogers about the DNA found on the glove compartment of Suzanne's Morphew's car? No, I don't believe so, Cahill said. Agent Cahill doesn't recall having a conversation with Agent Rogers on October 6th. I'm going to have to shut this down, the judge said. I think this motion was filed in August, and it was a lot more general. The witnesses, I had to let them speak for a while so I could understand where we were going. We have some rescheduling we will have to do. In a communication log, according to Eitan, there is a note about a game camera that had been put up near the Morphew's house. They don't know where it has been put up and would like to know any reports about the game camera. Judge Patrick Murphy has denied the defense's motion about the violation of pretrial publicity, saying there needs to be an affidavit. He says there needs to be a lot more detail than one sentence. The next time Barry will be in court will be Tuesday, December 14th at 1 p.m. to continue this motion's hearing about discovery violations. Eitan wishes the remaining witnesses to remain subpoenaed. Other motion hearings have been set for January 24th, 25th, and February 1st. Okay, let me see if there's... So... And that sounds really crazy. Let's see what we have here. So the gist of it is that Barry's defense team is claiming that prosecutors are keeping key evidence away from them. The defense started the hearing with a bold statement saying there is a black hole in this case when it comes to any evidence pointing away from Barry Morphew killing his wife, Suzanne. A deputy DA who was on the Morphew case previously was called alongside 6 other witnesses during the hearing. The 11th Judicial District says they are getting help from the 4th Judicial District's office to reformat the discovery in order to find information more easily. So it sounds like a mess with the hearings being... over, but let's get to these documents. All right, I'm going to pull them over. Okay, so earlier part 1, and I did link part 1 in the description of this video if you're brand new with us or didn't see it. You can find part 1. Part 1 was the public documents from May 2021 through to June 2021, and there were a lot of them. We're now going to look at the public documents from July 2021 through August 2021. Okay, and let me just pull this back. Okay. So this first one here is from the prosecution filed July 6th, 2021. The People's Response to Motion for Discovery and Sanctions D16. Come now the people of the state of Colorado by and through Linda Stanley, District Attorney for the 11th Judicial District, by and through her appointed Senior Deputy District Attorney Jeffrey D. Lindsay, hereby tenders their response to the above caption motion. 1. The instant motion was filed on June 24, 2021. Most local rules and practice allow for responses on motions to be filed 15 days after filing. This motion is being filed 12 days after the instant motion. 2. The people have been working on providing discovery since counsel entered their appearance. On June 2, 2021, counsel's investigator was given a hard drive with nearly a terabyte of data. A single terabyte is a lot of space. It would take 728,177 floppy disks or 1,498 CD-ROM disks to store just 1 terabyte worth of information. As of 2020, most new average price computers' hard drives are in the range of 1 to 5 terabytes. Terabytes, gigabytes, petabytes, how big are they? If you want to look, they have a livewire.com, they have a reference there. At the time, that was the extent of the discovery of the people had received from the various law enforcement agencies. Prior to the arrest of the defendant, most agencies had not compiled the discovery in a central location. The discovery was transferred to the Records Department in the Chaffee County Sheriff's Office, and upon receipt, the people transferred it to an external hard drive. Since then, the people have been providing discovery through the state system of e-discovery operated by the Colorado District Attorney's Council, the CDAC. As stated above and in open court, this is a huge case. The case has been investigated and assisted by numerous agencies, amongst others, the Chaffee County Sheriff's Office, the Salida Police Department, the Buena Vista Police Department, the Colorado Department of Corrections, the Colorado Bureau of Investigations, the Rocky Mountain Regional Computer Forensics Laboratory, the Chaffee County Search and Rescue, the Colorado Springs Police Department, the Colorado Parks and Wildlife, the Colorado State Patrol, Office of the District Attorney Investigations, the Gunnison Police Department, the Fremont County Sheriff's Office, and Federal Bureau of Investigation. The case has spanned across the state of Colorado and further into states such as Indiana, Florida, Arizona, Louisiana, Tennessee, Michigan, Texas, and the Republic of Mexico. Investigators have been working on this case daily since Suzanne was murdered. They have generated thousands upon thousands of pages of discovery. Suzanne Morphew is deceased. She has been missing since May 9, 2020. She has not been in contact with any of her loved ones or acquaintances since the afternoon of May 9, 2020. Investigators have not found her body. The defendant engaged in suspicious behavior the days leading to and after her disappearance, indicating consciousness of guilt. 5. Multiple media devices have been seized and searched pursuant to search warrants. The warrants limit what and where can be searched. When a phone is seized and searched, the agency conducting the search makes a mirror copy of the device and then conducts a search of the mirrored copy. Searching the mirrored image changes the file. The mirrored copy is retained by the searching agency. The search warrants define the limitations on what can be viewed, and analysts are careful to abide by the search warrant. 6. The results of the search warrants have been provided to counsel for Mr. Morphew. It is important to note that the searches of the many devices were limited to the permission granted by the search warrant. Counsel requests all mirror images of these devices, and while counsel may be entitled to the defendant's phone, the people do not believe that counsel for the defendant should have unfettered access to the mirror images of the other devices. The people believe that there are privacy interests attached to devices that do not belong to the defendant and, without a court order, cannot be searched. The people request a protective order preventing the search of devices that do not belong to the defendant. The UFDR file, which is the mirror image of the defendant's phone, was delivered to a defense investigator on July 6, 2021. It also includes the mirror image of, and those are redacted. In order to get copies of the phone, the agency had to start over and create a new mirrored copy since the copy they created had changed due to the search. The people had to make a special request and have that agency make said copy. This process is a time-consuming task, and the agency has other deadlines and work it conducts. The people made this file available the first business day after it was received. The people request protective orders enter regarding redacted UFDR phone files, preventing anyone from accessing these files beyond what is provided by the search warrants. The court entered the seal, ordered largely based on privacy interests of, most likely his daughters. In D16, counsel refers to the following files that they cannot open or access. Over the past 10 days, the people have provided the following information as listed below. The list is directly from the email and pleading filed by the defense. The people's response to their request is in purple. The following text files cannot be opened. And they list files here, okay? File extensions, URLs, stuff like that, okay? The following document files are corrupt, and they list some more. The following spy pen audio CoSprings audio files are corrupt and have a 0-byte file size. All of these are 0-bit files. They have nothing. Also, they have a thumb drive with EO1 file, etc., showing same to be rediscovered. See original copy, spy pen, audio, CoSprings, audio files, ELXS, doc that shows that they have 0 bits. The people have provided an email to counsel from the forensic investigator indicating even though they have the file names exist, the data appears to have been deleted, and then they list all of those. They're all MP3s. 10, the people have been in contact with counsel for the defendant and have been responding to their requests. The people have not failed to provide the information, but have endeavored to provide it as quickly as possible. Moreover, the people intend on continuing to provide discovery as contemplated by the rules. Respectfully submitted, Linda Stanley. Okay, and then the certificate of service. The next document, file July 6, 2021. To Linda Stanley, District Attorney for the 11th Judicial District, Jeffrey D. Lindsay, Senior Deputy District Attorney for the 11th Judicial District, and Aaron Pembleton, Deputy District Attorney for the 11th Judicial District. You are ordered to appear before the court at the place, date, time listed to show cause, if any, for the failure and refusal to comply with the orders of this court entered, and to vindicate the dignity of this court to show cause why sanctions and or imprisonment should not be imposed. You, Linda Stanley, District Attorney for the 11th Judicial District. Jeffrey D. Lindsay, Senior Deputy District Attorney for the 11th Judicial District, and Aaron Pembleton, Deputy District Attorney for the 11th Judicial District, are hereby ordered to appear at court location, District Court, Chaffee County, Colorado, Court 142, Crestone Avenue, Salida, Colorado, 81201. If you fail to appear in court at the time and date and place specified, a bench warrant will be issued for your arrest without further notice, and you will be further sanctioned according to the law for your failure to appear. Okay, and this one, let's see here, is order remotion to limit pretrial publicity. This matter comes before the court on defendant's motion to limit pretrial publicity. The court has reviewed the defendant's motion and the applicable authorities. Having heard argument from the parties on May 27, 2021, the court finds and orders as follows. Defendant has sought an order restricting pretrial publicity. Defendant's case has already received attention from the media. The case is likely to continue to generate media attention. In light of such anticipated publicity and the difficulty in anticipating all possible scenarios, this order is meant to provide guidelines to all involved in this case. Counsel involved in this matter will no doubt conduct themselves in a professional way. However, the nature of this case and the pretrial publicity that has already occurred, together with the anticipated publicity from the trial, demonstrate the need for court intervention to guide the conduct of counsel and those associated with them to avoid lowering the level of advocacy in this case. Without suggesting that there had been any violations of general ethical principles, it is necessary for the court to articulate the following to be followed in this litigation in the form of this order for further guidance, for future guidance in all forms of extrajudicial statements about this litigation. Colorado Rules of Professional Conduct 3.6 and 3.8 provide the basis for this order. Extrajudicial statements by attorneys, any lawyer, law firm, or legal representative, investigators of any firm associated with the prosecution or the defense, participating in or associated with the investigation or litigation of this criminal matter shall not, from the filing of a complaint, information, or indictment, the issuance of an arrest warrant or arrest until the commencement of the trial or disposition without trial, make or participate in making an extrajudicial statement that a reasonable person would expect to be disseminated by means of public communication, and that does more than state without elaboration, 1, the claim, offense, or defense involved, and, except when prohibited by law, the identity of the persons involved. 2, information contained in the public record. 3, that an investigation of this matter is in progress. 4, the scheduling or result of any step in litigation. 5, a request for assistance in obtaining evidence and information necessary thereto. 6, a warning of danger considering the behavior of a person involved when there is reason to believe there exists the likelihood of substantial harm to an individual or to the public interest. 7, the identity, residence, occupation, and family status of the accused. 8, if the accused has not been apprehended, information to aid in apprehension of that person. And 9, the facts, time, and place of arrest, as well as the identity of the investigating and arresting officers or agencies and the length of the investigation. B, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial, undue, prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. C, No lawyer associated in a firm or government agency with a lawyer subject to Section 1A above shall make a statement prohibited by Section 1A1-9. D. Any lawyer, law firm, or legal representative, investigators of any firm associated with the prosecution or defense, participating in or associated with the investigation or litigation of this criminal matter shall not, from the filing of a complaint, information, or indictment, the issuance of an arrest warrant or arrest until the commencement of the trial or disposition without trial, make or participate in making an extrajudicial statement that a reasonable person would expect to be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing adjudicative proceeding in the matter that relates to 1. The character, credibility, reputation, or criminal record of a party, suspect in a criminal investigation, or witness or identity of a witness, or the expected testimony of a party or witness. 2. In a criminal case or proceeding that could result in incarceration, the possibility of a plea guilty to the offense, or the existence of contents of any confession, admission, or statement given by the defendant or suspect, or that person's refusal or failure to make a statement. 3. The performance or results of any examination or test, or the refusal or failure of a person to submit to an examination or test, or the identity or nature of physical evidence expected to be presented. 4. Any opinion as to the guilt or innocence of a defendant or suspect in a criminal case or proceeding that could result in incarceration. 5. Information that the lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. Or 6. The fact that a defendant has been charged with a crime unless there is included therein a statement explaining that the charge is merely an accusation and that the defendant is presumed innocent until and unless proven guilty. E. During the selection of a jury or trial of this criminal matter, any lawyer or law firm associated with the prosecution or the defense of this criminal matter shall not make or participate in making an extrajudicial statement that a reasonable person would expect to be disseminated by means of public communication and that relates to the trial parties or issues in the trial or other matters that are reasonably likely to interfere with a fair trial, except that he may quote from or refer without comment to public records of the court in this case. F. Any lawyer or law firm associated with the prosecution or defense of this criminal matter shall exercise reasonable care to prevent his or her employees and associates from making an extrajudicial statement that he or she would be prohibited from making under this order. 2. Releases of information by law enforcement agencies. A. From the date of this order until the completion of the trial or disposition without trial law enforcement, officers shall not release or authorize the release of any extrajudicial statements or evidence for dissemination by means of public communication or to individuals other than those working for the parties. If the law enforcement officers know or reasonably should know that it will have a substantial likelihood of prejudicing a criminal proceeding, law enforcement officers and agencies are subject to the same restrictions set forth above for attorneys in Section 1 regarding extrajudicial statements. B. Law enforcement officers and agencies shall not exercise their custodial authority over an accused individual in a manner that is likely to result in either 1. The deliberate exposure of a person in custody for the purpose of photographing or televising by representatives of the news media, or 2. The interviewing by representatives of the news media of a person in custody except upon request or consent by that person to an interview after being informed adequately of the right to consult with counsel and of the right to refuse to grant an interview. C. Nothing in this order is intended to preclude any law enforcement officer or agency from replying to charges of misconduct that are publicly made against him or her, from participating in any legislative, administrative, or investigative hearing. 3. Disclosure by court personnel. Court personnel shall not disclose to any unauthorized person information relating to this pending criminal case that is not a matter of public records of the court and that may be prejudicial to the right of the people or the defendant to a fair trial. 4. Dissemination of discovery and evidence to individuals other than the parties, attorneys of record, and all law enforcement officers and agencies shall not release to anyone other than a party or to each other any discovery materials or investigative materials of any kind, except as and used by them for the purpose of furthering the investigation or for the preparation and trial of the case. 5. Applicability. Attorneys of record will be served a copy of this order, and this will constitute service upon the District Attorney's Office and Defense Counsel. The court orders the District Attorney's Office to comply with Colorado Rule of Professional Conduct 3.8 in exercising reasonable care to ensure all applicable law enforcement agencies, including the Chaffee County Sheriff's Office, the Colorado Bureau of Investigation, and the Federal Bureau of Investigation, and any other agencies who have participated in the investigation of this matter, all receive prompt notice of this order and comply with this order accordingly. Patrick W. Murphy, District Court Judge. And that was dated the 3rd day of June, but it was filed in July. Now we have another filing, July 6th. Motion for an order to show cause. This is filed by the defense team. Mr. Morphew states the following in support of this motion to enter an order directing Linda Stanley, District Attorney for the 11th Judicial District, Jeffrey D. Lindsay, Senior Deputy District Attorney for the 11th Judicial District, and Aaron Pembleton, Deputy District Attorney for the 11th Judicial District, hereinafter contemptors, to show as to why they failed to comply with the court's May 27, 2021 orders for discovery memorialized in the court's June 3, 2021 written order to produce all identified discovery to Mr. Morphew by June 2, 2021. Mr. Morphew suffers undisputed harms and violations of his constitutional rights to due process, bail, and effective assistance of counsel when he spends months in jail for the contenders' outlandish and bold accusation of murder in the first degree because 1. Mrs. Morphew went missing on May 10, 2020, and to this date she remains missing. There is no proof that Mrs. Morphew is deceased, much less murdered. Mr. Morphew has been in regular and frequent contact with law enforcement officers for the year following Mrs. Morphew's disappearance. Therefore, there was no immediate or urgent need to arrest Mr. Morphew on May 5, 2021. 2. However, on May 5, 2021, Mr. Morphew was arrested pursuant to the contemptors investigation penned affidavit for arrest where they were elected to charge Mr. Morphew with murder in the first degree. These contemptors requested that Mr. Morphew be held without bond, forcing him to remain jailed until at least the proof evident presumption grade hearing set to occur throughout the month of August 2021. 3. Despite the contemptors' rush to charge Mr. Morphew and create a media frenzy that they have not produced the discovery that has been in their possession for a year, and the discovery they used to draft the affidavit to arrest Mr. Morphew that their office authored, being understaffed, overworked, or incompetent, is no excuse to have Mr. Morphew arrested and held without bond, without proof of murder, and then fail to provide the court-ordered discovery. The contemptors have an obligation to provide this discovery, but have intentionally withheld this discovery subsequent to the May 27th, 2021 court order for discovery production to produce records by June 2nd, 2021. June 11th and June 17th, 2021 emails from undersigned counsel attached to defense motion for discovery sanctions requesting that the contemnors produce the withheld discovery. The defense motion for discovery sanctions D16, which is filed on June 24th, 2021. Mr. Morphew is concurrently seeking alternative remedy sanctions pursuant to Rule 16 violations, and July 1st, 2021 email request on for the intentionally withheld discovery. The contemnors themselves sought and obtained most of the withheld discovery through search warrants the court signed in May and June of 2020, and the contemnors heavily relied on that withheld search warrant returns when they assured this court that the affidavit for arrest their office authored was truthful and based on real and reliable evidence to support this court's signing a no-bond arrest warrant for murder in the first degree on May 4th, 2021. Many of the following search warrants were issued by the contemnors more than a year ago, but the records returned from these search warrants appears to have been intentionally withheld from Mr. Morphew. The returns of these search warrants include most of the alleged movement and activity of the Morphews and the Morphews children, and most, if not all, of the forensic images of the phones, including Mr. Morphew's. Mrs. Morphew's image of her iCloud account, as her phone is still missing, and computers seized in results of the forensic searches that have not been produced. Cellbrite forensics reports do not contain all of the data that was extracted from phones and computers. For judicial economy counsel requests the court takes judicial notice of the search warrants as they are not being attached hereto as exhibits, but are identified by their file names that are in the online court filing system, CCES. This is not a fully inclusive list, and they put the file names here. Additionally, no emails have been produced pursuant to June 2nd, 2021 court order. See Exhibit 1, Paragraph 3, granting D6 in part. Mr. Morphew does not want to continue this hearing and delay his hopeful release from jail and dismissal of the charges, but he is without this material evidence to prove definitively to the court what the contemnors have left out, exaggerated and misstated in the affidavit for arrest. With each passing day, Mr. Morphew's defense team is increasingly hampered in their ability to meaningfully and effectively prepare for the August hearings. And at the same time, the contemnors, in their willful and inexcusable disobedience of the court order and violations of their obligations and Rule 16, are attempting to use this to their advantage to wrongfully and unfairly to keep Mr. Morphew jailed. Every day these items are not produced is another day Mr. Morphew suffers harm, being unjustly jailed and costing him thousands of dollars for his defense team to visit him in the jail, working with experts without all of the data, and having increasingly limited time to review and analyze the discovery that the prosecution has failed to produce. Okay. 11. In order to vindicate the dignity of the court, counsel is seeking punitive sanctions for the contemnors Stanley, Lindsay, and Pembleton's failure to comply with this court's May 27, 2021 order for discovery production by June 2, 2021. Counsel is seeking punitive sanctions in the form of a meaningful fine calculated for every day the contemnors have failed and continue to fail to produce the court-ordered discovery. Counsel is not seeking punitive sanctions in the form of imprisonment. DA Stanley, Lindsay, and Pembleton are also on notice that counsel is also seeking remedial sanctions as a result of their pattern of misconduct that unreasonably interrupts the due course of judicial proceedings, obstructs the administration of justice, and disobeys the court's order and the rule of law. See Exhibit 4, motion for show cause pending against elected District Attorney Linda Stanley for failure to produce accessible discovery pursuant to the court order in People v. Nelson Manila Jr. Mr. Morphew is seeking the following remedial sanctions to remedy the untenable situation that has developed, which has permitted the DA to intentionally hold Mr. Morphew hostage and ensure that in the future the court orders will be followed. A. Immediate production of all records and all other outstanding discovery no later than July 7, 2021. And contemnors and involved law enforcement opening their file storage on this case to the defense team. And C. A discovery hearing wherein prosecution witnesses respond to questions regarding what discovery exists, the location of the discovery, including file names, and what has been produced. Hearing on defense motion for sanctions D16, where Mr. Morphew is seeking a bond be set in the alternative, the exclusion of the introduction of any evidence not produced to the defense resulting from the inexcusable Rule 16 violations. The court may, in its discretion, award costs and reasonable attorney fees to counsel in connection with this contempt proceeding. This includes investigatory and expert costs, wherefore, as a result of the contemnor's failure to comply with this court discovery order, counsel respectfully requests that this court issue an order to show cause and contempt citation as to why the contemnors shall not be held in contempt, issue punitive and remedial sanctions, and award the attorney's costs and reasonable attorney's fees associated with this contempt proceeding. Respectfully submitted under penalty of perjury the 6th day of July, 2021. The next one is the reply regarding the motion for discovery and sanctions and request for forthwith hearing D16A, filed July 7, 2021. Mr. Barry Morphew, by and through undersigned counsel, hereby replies to the district attorney's response to his June 24, 2021 motion for discovery and sanctions D16 and asserts the following. 1. The 11th Judicial District Attorney's Office made the decision to seek the arrest of Mr. Morphew on the charge of first-degree murder on May 4, 2021. Their decision necessarily triggered the Rule 16 obligations to obtain and provide all discovery pursuant to the law and court orders, regardless of the volume and the extent of the investigation. The documents produced to the District Attorney's Office by law enforcement agencies investigating the case hereinafter the prosecution, most of which were generated more than a year ago, as the result of search warrants that they authored and returns that they used in their affidavit to arrest, should have already been produced. The forensic images of Barry Morphew's redacted phones contain some of the critical evidence on which the prosecution bases their accusation, were just produced yesterday, July 6, 2021, a mere 30 days from the preliminary hearing and proof evident presumption grade hearing, and more than a month after the court ordered discovery be produced. 4. It appears that these forensic phone extractions were obtained pursuant to amended and third amended search warrants authored by May 23, 2020 by DA investigator Alex Walker IV on May 24, 2020. RMRCFL Jim Stevens placed the data on a 1 terabyte USB, and they turned it over to the FBI Special Agent Jonathan Grusing. The return and inventory for these phones was filed with the Chaffee County Combined Courts on July 30, 2020. There is no valid excuse, nor does the prosecution identify a reason in their response as to why the forensic images of these phones that the prosecution has had for nearly a year were just produced after numerous requests, 2 defense motions, and a court order. Contrary to their filed response during the hearing on May 27, 2021, the prosecution did not discuss that they did not have the discovery to produce, that they would be seeking protective orders, or state that there was any barrier to the failure to provide discovery. While the prosecution appears to have now turned over forensic images of Barry Morphew's phones and an Apple Watch, which total 539 gigabytes, the defense only has 30 days to download and analyze the data. However, without the remaining forensic data that the prosecution has in its possession, see below, but not produced, it may be futile. 7. The prosecution has failed to produce the forensic images from the vast majority of the devices that they seized and examined, and many other pieces of material evidence. See defense motion for order to show cause, Par 6. Importantly, the prosecution has still not produced the forensic images from the warrant return of Suzanne Morphew's iCloud account and the items images seized from the search warrant 20SW98, which include HP laptop, an Amazon Kindle, and an Apple laptop. While the prosecution has proven to be quick in downloading data for their own purposes and ferreting out the data they deem inculpatory, they have been dragging their feet in producing material discovery in an attempt to sandbag Mr. Morphew's chances of a fair hearing, where he has the ability to request that the court dismiss the charges and or have bond set. 9. Mr. Morphew requests the following sanctions, included 2 additional requests in italics. A reasonable bond amount to be set forthwith, or exclude testimony and introduction of evidence related to the discovery not provided by June 2, 2021, which was in the prosecution's possession prior to June 2, 2021, and order for the prosecution to produce all discovery and material and information outlined above by July 8, 2021, previously requested June 30th, 2021, and request for forthwith hearing on the motion for discovery and sanctions. Wherefore, Mr. Morphew makes all of these motions and all other motions and objections during all proceedings, in this case, whether or not explicitly stated at the time of the making of the motion or objection under the due process right to counsel, confrontation, right to remain silent, privilege against self-incrimination, bail, compulsory process, ex post facto, trial by jury, equal protection, right to appeal, and cruel and unusual punishment clauses of the federal and Colorado constitutions, and Article 2, 3, 6, 7, 10, 11, 16, 18, 20, 23, 25, and 28 of the Colorado Constitution, and Article 1, 9, and the 1st, 4th, 5th, 6th, 8th, 9th, 10th, and 14th Amendments to the U.S. Constitution. All prior authorities and citations noted apply to and support all requests for relief herein. Respectfully submitted this 7th day of July, 2021. Eitan Nielsen LLC. Okay, next we have filed July 8th, 2021. This is a request for a forthwith hearing on motion for discovery and sanctions, inoperable drive, D16B. Mr. Barry Morphew, by and through undersigned counsel, hereby request that the court set a hearing as soon as possible regarding Mr. Morphew's motion for discovery and sanctions D16, and states the following as additional grounds. The prosecution provided the forensic images of Barry Morphew's phones and of an iPad, which contains some of the critical evidence on which the prosecution bases their accusation. The hard drive that purports to contain these forensic images was not received by the defense until July 6, 2021. The prosecution has had the forensic images from these devices since May 24, 2020. On July 7, 2021, the defense, with the assistance of an experienced expert, attempted to open and access the files on the hard drive that was provided. The hard drive provided is not functional. The expert tasked with downloading and processing the discovery attests to the hard drive's lack of functionality in the attached affidavit. The prosecution's repeated failures in this case to provide timely, operable, and functional discovery pursuant to Rule 16 and the orders of this court do not appear to be isolated to this case. Upon information and belief, the Public Defender's Office and private counsel have advised undersigned counsel that this District Attorney's Office has failed to produce timely discovery in violation of Crim P 16 and court orders in many of their cases as well. See Exhibit 2, People v. Nelson Bonilla Jr. Custer County, Colorado, motion for show cause against District Attorney Linda Stanley for failure to provide accessible discovery. Just before the filing of this D-16 motion, Custer County District Court Judge L. Wenner issued the attached order to show cause for failure to comply with court orders in People v. Nelson Bonilla Jr. 4. The prosecution's misconduct is inexcusable and justifies sanctions as previously requested by Mr. Morphew, but the District Attorney's Office pattern failure to provide timely and operable discovery justify the imposition of a more significant sanction than originally requested to prevent this misconduct from reoccurring and continuing to prejudice Mr. Morphew. The significant and meaningful sanction requested is a dismissal or a reduction of the first-degree murder charge. Wherefore, Mr. Morphew requests a forthwith hearing on defense motion for discovery and sanctions D-16. This motion and all other motions and objections during all proceedings in this case, whether or not explicitly stated at the time of the making of the motion or objection under the due process, right to counsel, confrontation, right to remain silent, privilege against self-incrimination, bail, compulsory process, ex post facto, trial by jury, equal protection, right to appeal, and cruel and unusual punishment clauses of the federal and the Colorado Constitutions and Article 2, 3, 6, 7, 10, 11, 16, 18, 19, 20, 23, 25, and 28 of the Colorado Constitution and Article 1, 9, and the 1st, 4th, 5th, 6th, 8th, 9th, 10th, and 14th Amendments to the United States Constitution. All prior authorities and citations noted apply to and support all requests for relief herein. Respectfully submitted this 8th day of July, 2021. Okay, so now July 16th, 2021, 1:53 p.m. This matter is before the court on non-party media consortium's response to and request for reconsideration of the court's order granting defendant's motion to limit public access to the arrest warrant affidavit filed May 5th, 2021. No responses were filed. The court issues the following order affirming its June 4th, 2021 order and denying the motion for reconsideration. The media consortium questions the legitimacy of denying public access to the entire affidavit based upon the length and details contained within it, and also questions the likelihood that the information can't be redacted. However, it wasn't merely the details and length of the affidavit that resulted in the court's decision to restrict public access. It was also the court's desire that the efforts at redaction be done meaningfully and with reliable input from the parties, which cannot occur until the parties have had time to familiarize themselves with the investigation. To the extent the media relies on People v. Thompson, that case is distinguishable since it involved a record of official action. The media consortium maintains that there are multiple alternatives to restricting public access to the affidavit in its entirety, but the alternatives suggested only respond to abuse or harassment and do nothing to prevent it. There may be information contained in the 130-page affidavit that remains forever inaccessible to the public, but that may be released if efforts at redaction are done before the parties understand the case. Therefore, in furtherance of protecting the Morphew daughters from abuse or harassment, the court will allow time for meaningful efforts at redaction to be made. The media consortium also discusses Mr. Morphew's right to a fair trial. Aside from the court's concerns that the media consortium lacks standing to assert Mr. Morphew's right to a fair trial, the court does not agree with the argument that it is required by CRCP 55-1A6 to find that no less restrictive means exist to achieve or protect the defendant's fair trial rights. This is because Mr. Morphew's fair trial rights were not identified by the court as a substantial interest in its order. Therefore, there is no requirement that the court consider less restrictive means or balance Mr. Morphew's fair trial rights against the presumption of public access. Finally, the court sealed the Media Consortium's response, consistent with the language in CRCP 55.1, requiring that the clerk make the motion to limit public access and the response inaccessible to the public pending the court's resolution of the motion. Since the motion was granted, the response was kept sealed. However, the court can unseal this document in its discretion and make it accessible to the public during the time the motion is pending resolution. This implies that these documents could also be unsealed after the court has granted the motion. Given the content of the Medium Consortium's response, the court will unseal it as well as the media's motion for reconsideration. Conclusion: the Medium Consortium's motion for reconsideration is denied by the court the 16th day of July 2021. Date filed July 30th, 2021. Come now, the people of the state of Colorado, by and through Linda Stanley, District Attorney for the 11th Judicial District. Request the court allow for limited WebEx access to the currently scheduled preliminary hearing for the victim Suzanne Morphew's family. As grounds for this motion, the people informed the court as follows. At the last court date, July 22nd, 2021, the court informed the parties that it would not allow for the hearing to be broadcast over WebEx. The court stated that it needed to pay full attention to the evidence and that WebEx can be a distraction. The people have been in contact with Ms. Morphew's family. They expressed a desire to view the hearing over WebEx. Ms. Morphew's family lives in Indiana and Tennessee. The people are requesting limited WebEx viewing for Ms. Morphew's family, primarily her siblings, David Mormon, Andrew Mormon, and Melinda Mormon. The people have left messages to Ms. Morphew's daughters and are awaiting callbacks to see if they would want to also hear the case on WebEx. A severely limited amount of WebEx viewers would not distract the court. At most, it would be 5. The Mormon family would respect the dignity of the court and are aware that they could not record or photograph anything broadcast on the screen. The court recently allowed WebEx broadcasting in a preliminary hearing so the defendant's family could listen to the hearing. There was otherwise no purpose for allowing WebEx. All the parties, the defendant, and the witnesses were present in court. The limited number of viewers at the preliminary hearing did not distract the court. The people are aware the court has mechanisms to limit the participations in WebEx. In fact, the court routinely does so in juvenile cases in specialty courts. Allowing for the victims to participate via WebEx in the preliminary hearing would further the rights protected by the Victims' Rights Amendment to the Colorado Constitution, 16A of Article 2, and CRS 24.4, 1-302-5. And 1B, in order to preserve and protect a victim's rights to justice and due process, each victim of a crime has the following rights: the right to be informed of and present for all critical stages of the criminal justice process as specified in Section 24-41-3022. This would assist them in hearing the preliminary hearing, especially since the probable cause affidavit is sealed. Respectfully submitted, Linda Stanley. I'm just going to get a drink here. Hold on a second. I'm going to have it right here. I'm just going to... Okay. So this is now a renewed motion for discovery and contempt sanctions and forthwith hearing D17. Mr. Morphew, by and through undersigned counsel, renews and supplements his motion for discovery sanctions and for punitive contempt sanctions resulting from the prosecution's most recent and egregious violations of Colorado Rules of Criminal Procedure. Egregious violations of Colorado Rule of Criminal Procedure 16, the court's June 2nd, 2021 order, and the Colorado and United States constitutions. The prosecution just produced and has seemingly buried evidence of innocence dating back to October 2020. In support of Mr. Morphew's motions, he states the following. 1. Facts and procedural history. On May 27, 2021, Mr. Morphew appeared on the filings of charges, and the court ordered the DA to produce all mandated and other discovery by June 2nd, 2021. The prosecution did not indicate any barriers to making this timely production other than needing to bait stamp the discovery. 2. Also on May 27, 2021, the court set Mr. Morphew's preliminary hearing and proof evidence presumption great hearing to commence on August 9, 2021 and be completed on August 24, 2021. On June 2, 2021, the prosecution produced a hard drive. The defense was led to believe that all the mandated and court-ordered discovery was produced on the hard drive. 4. However, due to the prosecution's failure to produce the forensic image of Barry Morphew's cell phone and the Cellbrite reader, amongst a few other items noticed by the defense filed motion for discovery sanctions D16 on June 24, 2021. On July 6, 2021, the defense filed a motion for contempt citation. The court held a discovery sanction hearing on July 22, 2021. 5. At the July 22, 2021 hearing, the court determined the prosecution violated Crim P. Rule 16 and ordered the prosecution to produce the documents that the defense had been able to identify which had not been produced. 6. Since July 22, 2021, the prosecution has inundated the defense by producing massive amounts of new and what could be duplicative discovery, most of which existed in 2020 and certainly prior to the court's May 27, 2021 order, not including the discovery produced on Saturday, July 31, 2021 and the morning of August 2, 2021. This deluge of late discovery received between July 22nd through July 29, 2021 included more hard drives, flash drives, CDs, and 30 discovery receipts, representing 7,000 pages of discovery, hundreds of gigabytes of media, Cellbrite files, Sheila Oliver's cell phone downloads, Cellbrite image, which was collected in June 2020, 500 hours of video, and more than 30,000 photographs. On Saturday, July 31st, 2021, the prosecution dumped over 900 pages of discovery on the defense. Already as of this morning, August 2nd, 2021, by 11:59 a.m., the prosecution has provided 4 additional discovery receipts comprising of another 1,190 pages of new discovery. At first glance, the source of this newly produced discovery is Detective Robin Burgess. Yet, it appears that all of this discovery has been in existence and should have been produced on June 2nd, 2021. 8. Much of this deluge of untimely produced and mandated Rule 16 and court-appointed and court-ordered discovery was in the possession of and utilized by the prosecution, their investigator, and multiple law enforcement agents who participated in the drafting of the May 4, 2021 affidavit for arrest. Despite having this material for months, the prosecution produced this massive discovery nearly 2 months after the court-ordered discovery deadline, while Mr. Morphew remains held without bail. Because of this late, immense dump of discovery production it is difficult on the evening of the preliminary hearing to ascertain what has been produced, what has not been produced, what is in the possession but has not been produced, and what is operable. In addition to this massive withholding of discovery in violation of the court orders, the prosecution has still failed to produce the 26 exhibits that FBI agents placed in front of Barry, including photos Suzanne sent to Libler, cell phone data, search records, search photo, timelines of his activities on May 9th and May 10th, surveillance photos, and the prosecution has not produced the data from the computers identified. Additionally, it does not appear that the prosecution has produced any recent reports detailing law enforcement's ongoing search efforts for Ms. Morphew or body cam footage or related reports from the search of the Morphew's residence from May 11th to May 15th, 2020. In one of the discovery productions since July 22nd, 2021, the prosecution produced a critical letter buried among the mass. The letter is dated May 19th, 2021, and is from CBI CODIS Administrator Douche, and that's the one we just heard about in court today. To CBI Agent Christopher Adams, CBI Agent Joseph Cahill, and Chaffee County Sheriff's Office Detective Robin Burgess, and is titled CODIS DNA Casework Match. 11. The CODIS DNA match letter from CBI's CODIS unit states that DNA profile from the swabs taken from Suzanne Morphew's car glove compartment matches the DNA profile of 3 other unsolved sexual assaults that occurred in Tempe, Arizona, Phoenix, Arizona, and Chicago, Illinois. It is outrageous that this undeniably exculpatory letter was not produced until July 23, 2021. Even more egregious is that law enforcement has had this exculpatory information since October 2020. The prosecution withheld this information from Mr. Morphew and from the court when they submitted the lengthy affidavit for arrest of Mr. Morphew on first-degree murder. The May 4th, 2021 affidavit, authored by then Chief Investigator Alex Walker, was reviewed by the following attorneys with the 11th Judicial District Attorney's Office: District Attorney Linda Stanley, Senior Deputy District Attorney Jeff Lindsay. Additionally, the affidavit indicates that it was edited and reviewed by CBI Agent Joseph Cahill. Instead of including this material and exculpatory information in the affidavit, the prosecution chose to include irrelevant, inflammatory, and speculative statements and hypotheses. As background, on May 10, 2020, the day Suzanne Morphew was discovered missing, her car was found parked in the garage of the residence. Law enforcement immediately secured the Morphew house and the garage. The glove compartment was swabbed. The swab revealed a DNA mixture of 3 contributors, including at least 1 male donor. Barry Morphew and numerous males, both lay people and law enforcement officers, were excluded from the DNA profile lifted from the glove compartment. The Combined DNA Index System, CODIS, is the FBI's program to provide support for criminal justice DNA databases around the country. CODIS is designed to compare a target DNA record against the DNA record contained in the database. Many unsolved or cold cases are solved using CODIS, and CODIS hits are often a means to establishing probable cause to obtain an evidentiary DNA sample from a suspect. There are approximately 20 million DNA profiles included in the CODIS database. The defense has organized for the court what the defense has been able to find in the discovery related to the CODIS matches from the foreign unknown male DNA found on Suzanne Morphew's glove compartment to an unknown male or males involved in 3 prior sexual assaults in 2 other states. Tempe CODIS match, October 22nd, 2020, letter from CBI Administrator Duge titled CODIS DNA Casework Match to Debbie Kennedy at Arizona Department of Public Safety, identifying the October 12, 2020 match from the DNA profile found on Suzanne Morphew's car glove compartment to an unsolved sexual assault in Arizona. Mrs. Duge identified Detective Robin Burgess and CBI Agent Cahill as contacts. Letter and other correspondence between CBI Megan Duge and the Arizona Department of Public Safety. B. Phoenix CODIS match on November 19, 2020. A letter from CBI admin Duge titled CODIS DNA Casework Match to Jennifer Palmer at the Phoenix PD Crime Lab, identifying the October 16, 2020 match from the DNA profile found on Suzanne Morphew's car glove compartment to a sperm fraction of underwear in an unsolved sexual assault in Phoenix, Arizona. Ms. Duge identified Detective Robin Burgess and CBI Agent Cahill as contacts. See Exhibit 2, letter and other correspondence between CBI Megan Duge and the Phoenix PD Crime Lab. C. Illinois CODIS match on April 28, 2021, letter from CBI admin Duge titled CODIS DNA Casework Match to Karen Avenatti of the Illinois State Police, identifying the March 18, 2021 match from the DNA profile found on Suzanne Morphew's car glove box to an unsolved sexual assault in Illinois. Ms. Duge identified Detective Robin Burgess and CBI Agent Cahill as contacts. See Exhibit 3, letter and other correspondence between CBI Megan Duge and the Illinois State Police. Despite being aware of the CODIS matches, the prosecution has not produced the police reports or DNA packages from the unsolved sexual assaults, wherein the DNA of the individual involved in these cases matches the foreign unknown male DNA on Suzanne's car glove compartment. Looking deeper in the late discovery production, the prosecution is rightly concerned about the unknown male DNA profiles identified on the glove compartment and the other evidence. But it does not appear the prosecution has produced the follow-up investigation conducted on the CODIS matches or the unknown male DNA profiles found on the bike helmet, and the vehicles. This evidence of innocence was hidden among the droves of discovery dumps the defense has been receiving since the last hearing on July 22, 2021. The defense did not know about and therefore could not ask about this withheld discovery. This is exactly the reason why the defense should not have the burden to request discovery. Given the prosecution's untimely and unorganized procedure and misconduct, the defense cannot be held to know what other exculpatory information the prosecution possesses but has buried and not identified. 21. The masses of late discovery dumps, the failure to produce what was ordered on July 22, 2021, and the failure to timely reveal or indicate the CODIS matches while an innocent man remains locked in jail, constitutes outrageous governmental misconduct. Argument for sanctions. Outrageous governmental conduct. Mr. Morphew's constitutional rights to due process, effective assistance of counsel, and bail have been violated due to outrageous governmental conduct. The United States Supreme Court has recognized the existence of the legal defense of outrageous governmental conduct. And it states that case, okay? Outrageous governmental conduct is conduct that violates fundamental fairness and is shocking to the universal sense of justice. Exercise of a court's supervisory powers in dismissing a case may be proper if the government's conduct has violated fundamental fairness and is shocking to the universal sense of justice. The Colorado Court of Appeals further held that when the integrity of the court is compromised, as here by overzealous prosecution, dismissal of the case is an appropriate remedy. Such action is predicted on the Due Process Clause of the Fifth Amendment to the United States Constitution and has generally been characterized as the defense of outrageous government conduct. This defense was first recognized by the United States Supreme Court in United States v. Russell. Outrageous government conduct may be invoked in any case that challenges the actions of government officials. This defense protects defendants from government action that is so overreaching or otherwise offensive as to contravene the values implicit in a concept of ordered liberty. Here the discovery, malpractices, and prosecution's withholding of material and favorable evidence is outrageous, and the case should be dismissed. If Mr. Morphew was not being held in jail without bond and waiting another 4 weeks for the court to make a determination of probable cause, the prosecution's misconduct would still be egregious. But in this circumstance, the prosecution rushed to arrest Mr. Morphew without evidence of murder when they were not ready to fulfill their prosecutorial duties. After Mr. Morphew had been in jail without bond for nearly 3 months, the prosecution produced, in a mass production and without note, the previously withheld material evidence of 3 CODIS matches between an unknown male in 3 unsolved sexual assault cases and an unknown male's DNA found in Suzanne Morphew's car. Law enforcement has been aware of a CODIS match since October 2020. If the court finds that a dismissal is not the appropriate remedy for the prosecution's violation of Mr. Morphew's constitutional due process rights, then Mr. Morphew requests the court set reasonable bail or reduce the charge to second-degree murder. If the court is authorized to dismiss a case entirely, then it must be authorized to set reasonable bail on a case. B. Rule 16 and Brady violations and request for contempt sanctions. The prosecution continues to violate Rule 16 and May 27, 2021 court order. The prosecution's late and withheld productions of discovery are further proof of a pattern of neglect and intentional withholding of evidence of innocence. The purpose of discovery is to ensure fair process, aid the accuracy and efficiency in the search for truth, reduce the risk of trial by ambush, and to protect innocence. Surely, mandatory discovery and court-ordered discovery should be produced on time and in an orderly fashion. All exculpatory evidence must be disclosed before any critical stage in the proceeding, which includes a preliminary hearing or proof-evident presumption grade hearing. The July 28, 2021 email from D.A. Lindsay stating most of the discovery was not part of the order, but we will have him deliver it tomorrow, illustrates that the prosecution still does not understand its mandatory Rule 16 obligations. Mere negligence or ignorance does not negate a claim that discovery was not provided, or exculpatory evidence was concealed or delayed. The fact that the prosecuting attorney does not have any actual knowledge of the information withheld does not absolve the Rule 16 violation. The defense does not have to prove that the prosecution had malintent or bad faith in the delayed production. Proof of materiality is not required for the court to find a Rule 16 violation, although it is for the court to find a Brady violation. Here, the withheld and delayed production of the CODIS matches from the DNA profile from Suzanne Morphew's glove compartment to 3 unsolved sexual assaults is material and exculpatory and not produced in violation of Mr. Morphew's due process rights. Rule 16 in case law specifically designates that the prosecutor's obligations extend to material information in the control of any others who have participated in the investigation or evaluation of the case. The prosecution not only has a duty to learn and retrieve from law enforcement any evidence favorable to the defense, they also have to produce it. June 4th, 2021 June 4th, 2021 court order regarding hearing on May 27, 2021. In this case, it is apparent that the prosecution does not know what it has, nor what has not been produced. At the same time, the prosecution has withheld evidence of innocence, all the while Mr. Morphew remains in jail. Placing the burden on Mr. Morphew is inconsistent with Brady and its progeny of cases. What is happening here is that the defendants must scavenge for hints of undisclosed Brady material when the prosecution represents that all such material has been disclosed. Rule 16 addresses sanctions for violations and states if at any time during the course of the proceedings it is brought to the attention of the court that the party has failed to comply with this rule or with an order issued pursuant to this rule, the court may order such party to permit the discovery or inspection of materials not previously disclosed, grant a continuance, prohibit the party from introducing in evidence the material not disclosed, or enter such other order as it deems just under the circumstances. In this case, the prosecution failed to produce critical exculpatory evidence until July 23, 2021. And on Monday, August 2nd, 2021, the prosecution continues to produce thousands of files that predated Mr. Morphew's arrest. It seems that without the defense motions, requests for sanctions, and court orders, that this discovery and evidence of innocence may never have been produced. Because of the prosecution's late discovery of critical information that needs follow-up analysis and investigation, Mr. Morphew is being denied his rights to effective assistance of counsel, to adequately prepare and present a defense, to face and cross-examine his accusers, to call expert witnesses on his behalf, and to due process under the law of the United States and Colorado constitutions. Due to exculpatory evidence being produced so late, the defense is unable to conduct necessary independent and reasonable examination with experts, obtain necessary reports and information about 3 matching unsolved sexual assaults, or conduct follow-up investigation prior to the preliminary and proof-evident presumption grade hearings. Okay, hold on a second. Where were we? Hold on a second. Where were we? Great hearings. What just happened here? Hold on a minute, because somehow I lost where we were. What the frick happened here? I just said, the last thing I said was great hearings. And I can't find it. Oh, here we go. I found it. My gosh, that was crazy. The court has broad and absolute discretion to impose sanctions when a party has failed to comply with the rule. Sanctions shall be imposed that will cure the prejudice, protect the integrity of the truth-finding process, and deter discovery-related future misconduct. The court may impose discovery sanctions that will adequately remedy the violation and level the playing field. In doing so, among the factors the court should consider: 1, the reason for the delay in providing the requisite discovery, any prejudice a party suffered because of the delay, the feasibility of curing any prejudice through a continuance. However, when there is willful misconduct or a pattern of neglect demonstrating a need for modification of a party's discovery practices, harsher sanctions may be imposed. Otherwise, a court should use sanctions only as a means to cure the prejudice resulting from the discovery violation. The 11th Judicial District Attorney's Office has shown a pattern of neglect reflected by the numerous discovery violations. Defense created a chart of known Rule 16 violations recently issued against the 11th Judicial District Attorney's Office. The pattern of neglect in this case and in the DA's office continues. In this short and critical time period leading up to the critical stage of the preliminary hearing and proof evident presumption grade hearing, the prosecution has exhibited willful misconduct and a pattern of neglect which requires the court to cure the extreme prejudice to Mr. Morphew. The court has the authority to issue any sanction unless it is manifestly arbitrary, unreasonable, or unfair. Mr. Morphew requests the court dismiss this case or reduce the charges. The court has the authority to dismiss a case when exercising its supervisory authority to dismiss or on constitutional grounds, infringement of the defendant's due process rights, when exercising its supervisory authority to protect the integrity of the judicial process, prosecutorial misconduct that interferes with the grand jury's independent function upon determination that the evidence is insufficient to support prosecution when authorized by the statute that is consistent with constitutional separation of powers, to transfer from the courts to the prosecutor the power to dismiss pending criminal proceedings against incompetent defendants. The court has the authority to reduce charges in a case and can do so here as a sanction for violation of the Constitution in Rule 16. District Court has authority at preliminary hearing to bind over a defendant on a lesser included charge. The court may instruct a jury on lesser included offense if there is supporting evidence. District Court may instruct jury on lesser non-included offense if the defendant requests or consents to it. District Court has authority to submit jury instruction on lesser included offense after granting judgment of acquittal on a greater offense. Understanding that the court may consider dismissing this case or reducing the murder in the first-degree charge as an extreme request, Mr. Morphew alternatively requests that the court set a reasonable bond in light of the egregious Rule 16 and constitutional violations. As Rule 16 in the Constitution authorized the court to dismiss a case and to reduce charges, which would then mandate a bond being set, the defense asserts that the court has the authority to set a reasonable bond. Setting a reasonable bond is not arbitrary, unreasonable, or unfair, but an attempt to remedy the prejudice to Mr. Morphew. Further, Mr. Morphew requests that the court find that the prosecutors, as identified in the contempt citation, are in contempt of court by violating the court order to produce all mandated discovery by June 2, 2021. Mr. Morphew requests this court issue a contempt sanction to reimburse Mr. Morphew for attorney fees and costs for the enormous amount of time and expense incurred by the defense to organize and decipher mass amounts of untimely discovery and to draft and argue discovery motions. Mr. Inventory. Mr. Morphew also requests, as a non-sanction, that the prosecution present the defense with an inventory of all discovery that exists and the discovery that has been produced. The prosecution has produced and reproduced multiple items in this case by various individuals in various forms, via the CDAC e-discovery website, via CDs, via hard drives, and via thumb drives. Mr. Morphew requests the court enter an order directing the prosecution to provide a list of the items, the specific documents, audio recordings, video recordings, photographs, etc. the prosecution has in this case and has produced in this case. Given the haphazard and inconsistent way the prosecution has produced discovery in this case, an inventory should be required. The court and defense counsel have spent considerable time addressing these issues rather than the substantive case itself. It would streamline and simplify matters and the expenditure of unnecessary time and resources to have an inventory of the prosecution's production. 4. District Attorney's witness list for the August hearings. At the last hearing on July 22, 2021, the court directed the prosecution to provide a witness list to the defense. That has not been provided. The defense has requested of the prosecution to provide a list of witnesses that they intend to call on August 9th and 10th, 2021. So far, they have not agreed to provide a witness list. Given the mass amounts of discovery being dumped on the defense, and that there was a previous indication of 18 witnesses, the defense cannot be expected to be prepared to effectively cross-examine 18 witnesses 1 week from today. As such, Mr. Morphew requests, as a non-sanction, that the court order the prosecution to produce by close of business on August 2nd the witnesses and the order of witnesses they intend to call on August 9th and 10th, 2021. Wherefore, Mr. Morphew requests a forthwith in-person hearing on this motion. At the hearing, the defense requests that the prosecution and law enforcement officers be required to answer to what they know about the CODIS matches. The motion and all other motions and objections during all proceedings in this case, whether or not explicitly stated at the time of the making of the motion and objection under the due process right to counsel, confrontation, right to remain silent, privilege against self-incrimination, bail, compulsory process, ex post facto trial by jury, equal protection, right to appeal, and cruel and unusual punishment clauses of the federal and Colorado constitutions. Okay, all prior authorities, citations noted apply to support all requests for relief herein. Respectfully submitted the 2nd day of August 2021. Okay, I'm going to get a drink here. Let's see. Supplement to renewed motion for discovery and contempt sanctions and forthwith hearing D17A. Mr. Morphew, by and through undersigned counsel, supplements his renewed motion for discovery sanctions and for punitive contempt sanctions D17 resulting from the prosecution's most recent and egregious violations of Colorado Rule of Criminal Procedure 16, the court June 2nd, 2021 order, and the Colorado and United States constitutions. In the past 24 hours since filing D17 yesterday, August 2nd, 2021 at 12:38 p.m., the defense has received an additional 16 discovery productions comprising of 4,936 files, which include both PDF and non-PDF files such as Excel files and JPEG images. Discovery receipts in the last 24 hours since filing the renewed motion for discovery and contempt sanctions D17. We were also notified yesterday afternoon, August 2nd, 2021, after the filing of the renewed motion, that the defense will be receiving yet another discovery production via FedEx for delivery today, August 3rd, 2021, containing the surveillance dump and the phone dumps from search warrants executed at the time of the arrest of the defendant. See Exhibit B, August 2nd, 2021, email regarding additional discovery production. The delivery has not been received as of the filing of this supplement. Additionally, this morning, August 3rd, 2021, we were notified that yet another hard drive containing video files is being sent via FedEx, which is scheduled to arrive prior to 10:30 a.m. on August 4th, 2021. See Exhibit C, August 3rd, 2021, email notification of additional hard drive production. Wherefore, this motion and all other motions and objections during all proceedings in this case, whether or not explicitly stated at the time of the making of this motion or objection under the due process, right to counsel, confrontation, right to remain silent, privilege against self-incrimination, bail, compulsory processes. Okay, we're not going to go through this again. Respectfully submitted the 3rd day of August 2021, Eiton Nielsen, LLC. Date filed August 3rd, 2021. Mr. Barry Morphew, by and through undersigned counsel, respectfully requests and he be afforded the opportunity to dress out in a non-jail uniform for the preliminary and proof evident presumption grade hearing. If the court allows this, the defense will provide Mr. Morphew clothes to the jail in advance of the hearing. Wherefore, Mr. Morphew respectfully requests the court issue an order allowing Mr. Morphew to dress out for the upcoming preliminary and proof evident presumption grade hearing, respectfully submitted this 3rd day of August 2021. Eitan Nielsen. Okay, so the next one is response to defense motion for contempt. Come now, the people of the state of Colorado, by and through Linda Stanley, District Attorney for the 11th Judicial District, hereby tenders the following response to the motion for contempt filed by the defendant. As grounds for this motion, the people inform the court as follows. 1. Shortly after the hearing, the people met with all law enforcement agencies involved in this case. At that time, the undersigned ordered all agencies to conduct an audit of their files and evidence being held. Undersigned trusted all agencies to do the audit inventory. 2. In response to the audit, all agencies undertook a submission that brought forth the discovery. In order to ensure all discovery has been provided, the discovery was provided to the defense. It was done so through an investigator who made 2 separate trips to the office of the attorney for the defendant. 3. The majority of the discovery, largest amount of data provided over the past week, is from 2 sources. First, the Colorado Bureau of Investigation, CBI, received a large number of YouTube videos from an independent filmmaker, Tyson Draper. All of the videos provided to CBI were subsequently provided to the defendant last week. The videos were on YouTube and were available to the defense. Since CBI had them and provided them, this office in turn provided them to the defense. Second, the week of May 5th through May 10th, investigators obtained videos from several surveillance cameras throughout the area. The files recovered were viewed by the Chaffee County Sheriff's Office personnel, and various stills were identified and captured. The stills have been provided in discovery in multiple formats. The raw video has not been provided and is not being provided. The remaining discovery is the continuing discovery flow that is typical in all cases. The discovery is the searches of the defendant's condo, Shoshana Dark's residence, multiple storage units, and the reports of those occurrences. There is likely duplicative discovery, and while this may frustrate the defense, it is going to go out in discovery nonetheless. If the Office of the District Attorney receives case submission from a law enforcement agency, it will be released in discovery. Regarding the alleged exculpatory issues cited by the defense, the people have provided these details over the course of the investigation. CODIS leads. Tempe CODIS. This was referred to CBI agent Joseph Cahill, and a report was generated, CBI Report 546, attached as Exhibit 1 to this response. Agent Cahill's report references the CODIS referral, the contact in Tempe, Arizona, the agency, and the case number. The report was released in the initial round of discovery June 2nd, 2021. B. Phoenix CODIS. Upon the receipt of the motion on August 2nd, 2021, the undersigned inquired of Agent Joseph Cahill and Detective Burgess. It does not appear that either did any work on this alert. Undersigned directed both the agent and detective to inquire and get information from this alert immediately. Undersigned inquired regarding this information and is aware that both Agent Cahill and Detective Burgess have also contacted the authorities in Phoenix. Today, August 3rd, 2021, CCSO received documents from Phoenix Alert. They have been pushed out in the discovery and are attached as Exhibit 2. Chicago CODIS. This was referred to as CCSO Robin Burgess, who upon receipt of the letter from CBI obtained reports from the Chicago Police Department attached as Exhibit 2 to this response. This was attached to report number 99, authored by Detective Burgess and placed in the discovery queue. Report number 99 was released to the defense on August 2, 2021. Regarding the search warrants for the 3 devices, please see attached Detective Robin Burgess supplemental report documenting these devices. We have provided in discovery what we have been provided by the RMRCFL. Reference these devices. Detective Burgess report is attached as Exhibit 4, dated August 3rd, 2021. Order regarding protocol for preliminary proof evident hearing. This matter is set for a 4-day combined preliminary hearing, proof evident presumption grade hearing. The hearing is set for all day on August 9th, 10th, August 23rd, and August 24th. As stated on the record on July 22, 2021, the court does not intend to broadcast these proceedings to the public via WebEx. The court made this decision for several reasons. First, the court does not believe it has the legal authority to do so. Pursuant to Colorado court rules, only certain pretrial hearings are eligible for expanded media coverage in criminal cases. Preliminary hearings are not included on that list. While Colorado courts have utilized the WebEx platform extensively during the pandemic and continue to do so, court views this particular case in a different manner. This case has generated enormous public interest, and broadcasting the proceedings via WebEx would very likely result in thousands of people viewing the hearing, and this would seem to thwart the purpose of limiting expanded media coverage in criminal cases. Those purposes include not interfering with the rights of the parties to a fair trial, not detracting from the decorum and dignity of the court, and not creating adverse effects that would be greater than those caused by traditional media coverage. By way of illustration, at a prior non-evidentiary hearing, over 1,100 devices joined the WebEx meeting and viewed the proceedings. Numerous messages, many of which were inappropriate, were posted in the chat feature. The court is aware that despite a prohibition on recording and rebroadcasting, the proceedings were recorded and rebroadcast. The fact that it would be the court broadcasting the proceedings and not the media does not alter the court's thinking. The same rationale applies. Additionally, on July 8, 2021, Colorado Governor Jared Polis declared an end to the public health emergency created by the pandemic. Therefore, broadcasting the hearing via WebEx due to ongoing public health emergency is no longer a valid rationale. Finally, the court is the trier of fact at a preliminary proof evident hearing. The court needs to focus all of its attention on the proceedings. Monitoring the WebEx meeting during the hearing would divide the court's attention and create a distraction. Public access to the hearing. The Chaffee County Combined Courts have received the approval of the Chaffee County Department of Public Health to conduct in-person hearings. The court agreed to limit capacity in courtrooms by adhering to 3 feet of social distancing. The court also agreed to mandating masks in courtrooms for participants, judicial employees, and observers. These rules will allow for approximately 24 members of the public or media representatives to view the hearing in person. The court understands that without the distancing requirement, more members of the public would be able to view the proceedings, almost twice as many. The court now also understands that significantly more than 24 people or members of the media will want to view the proceedings. Therefore, with the help of Chaffee County, the court will live stream the proceedings into the main hall of the Chaffee County Fairgrounds. This should provide seating for additional 40 or 50 additional people, for approximately 40 or 50 additional people. The live stream will only be accessible to the judicial laptop at the Fairgrounds building and to immediate members of the Morphew Mormon families. The public will not have access to the live stream. Family of victim. The prosecution has requested that Suzanne Morphew's siblings be able to view the proceeding via the live stream. The prosecution has asked that the Morphew children be able to view the proceeding via the live stream, but does not know their intention. Siblings and children of a victim are considered victims for purposes of Colorado's Victims' Rights Amendment. Under the Victims' Right Amendment, the court has the obligation to ensure that victims are informed of and be present for all critical stages of a criminal case. A preliminary hearing is a critical stage of a criminal proceeding. Because the siblings reside in another state and are otherwise unaware of the facts supporting Mr. Morphew's arrest due to the court's suppression of the arrest affidavit, the court will allow them to view the proceedings via the live stream. Similarly, if the Morphew children desire to watch the proceeding via live stream, the court will allow this as well. The court believes that this will satisfy the court's responsibilities under the Victims' Rights Amendment, without leading to some of the concerns noted above regarding the general public viewing the proceedings via live stream. Order. All participants, judicial employees, and observers must maintain social distancing of at least 3 feet and must wear masks. Masks may be removed by participants when speaking and by witnesses when testifying. There will be approximately 24 people admitted into the courtroom to observe. 7 of those seats will be reserved for the media, and the rest will be reserved for the general public. The media seats will be apportioned by the Deputy Public Information Officer, John Sarch. Please contact Mr. Sarch for details. Public seating will be on a first-come, first-served basis. Additional seating and a live stream will be provided at the Chaffee County Fairgrounds main building. Live tweeting or reporting of the proceedings will be allowed unless disruptful to the process. Recording of the proceedings is prohibited. The siblings and children of Suzanne Morphew may view the proceedings via WebEx. The court will need the email addresses and device name for each family member that wants to view the proceedings via live stream. By the court this 4th day of August, 2021, Chief Judge, 11th District, Patrick W. Murphy. Mr. Bear forthwith motion to provide good faith list and order of witnesses for the August 9th and 10th hearing by close of business D19. Mr. Barry Morphew, by and through undersigned counsel, moves this court for an order directing the prosecution to provide a good faith realistic list and order of the witnesses they intend to call at the August 9th, 10th, 2021 hearing. As grounds, Mr. Morphew asserts the following. After several requests to the prosecution to provide a witness list for the hearing, the prosecution provided an 18-person witness list on July 21st, 2021. Their list includes 8 Chaffee County Sheriff's deputies, 5 Colorado Bureau of Investigation agents, 2 Federal Bureau of Investigation agents, and 3 lay witnesses. Given the time constraints of the hearing and in an effort to be prepared to cross-examine the witnesses who will actually be called, the defense raised this issue to the court at the hearing on July 22, 2021. While it is not reflected in the minute order, it is defense counsel's recollection that the court did order the prosecution to provide an updated good faith list of witnesses. Not having received a narrowed down good faith list of witnesses, undersigned counsel again contacted Mr. Lindsay on August 1st, 2021, requesting that the prosecution provide the witness list and order that they anticipate calling the witnesses for the August 9th and 10th hearing. Mr. Lindsay indicated that he would consult with his team and let us know whether we can provide such. It might be closer to Friday before we do so. Email correspondence between counsel regarding the witness list. Defense counsel again followed up with Mr. Lindsay on August 3rd, 2021, requesting a witness list. As of the filing of this motion, no response has been received to the latest request. Given the voluminous, untimely, and ongoing discovery production, the length of investigation in this case, and the number of potential witnesses, 18, in the interest of fairness, the defense requests that the court order prosecution to disclose to the defense by close of business today, August 4th, 2021, a good faith list and order of witnesses. I'm going to get a drink here. This will allow the defense to focus and prepare for those witnesses who will actually be called the first 2 days of the hearing. This will promote Mr. Morphew's constitutional rights to effective assistance of counsel and ability to confront and cross-examine the witnesses against him. This request does not unfairly prejudice the prosecution, nor is it burdensome. Colorado Rule of Criminal Procedure 57A gives the court the authority to order the good faith lists and order of witnesses. If no procedure is specifically prescribed by the rule, the court may proceed in any lawful manner not inconsistent with the rules of criminal procedure. Wherefore, the defense requests that the court order the prosecution to disclose to the defense by the close of business today, August 4th, 2021, a good faith list and order of witnesses. Respectfully submitted the 4th day of August. Okay. The second supplement to renewed motion for discovery and contempt sanctions and forthwith hearing Mr. Morphew by and through undersigned. Okay, we're going to skip that. That's the same. Okay. Since filing D-17 on August 2nd, 2021, and D-17 filed on August 3rd, 2021, the defense has received an additional 4 discovery productions comprising of 173 files. As of 10:26 a.m. today, August 4th, 2021, the defense received via FedEx 1 hard drive containing 203 gigabytes of data. DA discovery receipts and photos of hard drive and content received in the last 24 hours. While we received the hard drive from the file descriptions, it appears that this is not newly acquired discovery, but discovery that existed and should have been produced on June 2nd, 2021. Wherefore, this motion and all other motions and objections during all proceedings in this case, whether or not explicitly stated at the time of the making of the motion or objection under the due process, right to counsel, confrontation, right to remain silent, privilege against self-incrimination, bail, compulsory process, ex post facto, blah, blah, blah. We've done this already. All prior authorities and citations noted apply to and support all requests for relief herein. Respectfully submitted the 4th of August. Okay. Notice of endorsement of witnesses. Linda Stanley, District Attorney in and for the 11th Judicial District, State of Colorado, hereby notifies the defense and court of the endorsement of the following witnesses in the above entitled case: Alex Walker, Robin Burgess, Claudette Julian, Andrew Horowitz, Damon Brown, Scott Himshoot, Lamine Mulinax, Derek Graham, Joseph Cahill, Tanya Atkinson, Dennis Honeycutt, Jonathan Grusing, Kenneth Harris, Miles Harvey, Gene Ritter, Martin Ritter, Randy Caricato, Kevin Kobach, William Plackner. Respectfully submitted the 4th day of August 2021 by Jeffrey D. Lindsay. Appearance bond felony. State of Colorado versus Barry Lee Morphew. We have cash bond type. Okay. Name of party, Barry Lee Morphew. Date of birth 10/17/1967. Okay, so this is these boxes are electronic home monitoring. Other comply with no contact protection orders. Other surrender passport. Other wear an ankle monitor at the expense of the defendant not to possess any firearms or weapons. Complete a firearm affidavit. Defendant will post bond no earlier than noon on 9/20/21. Report to probation intervention upon release. Defendant's name, Barry Lee Morphew. If the party fails to comply with any of these conditions of the bond, the court may revoke the party's release on bail, increase the amount of bail, or modify bond conditions. The bond will be forfeited if the party does not appear in court as required by the primary bond condition. Okay, so I do consent or authorize the court to apply the cash bond deposited, in this case, towards any amount owed by me. Signature. Bond. I, Barry Lee Morphew, have been arrested for a felony offense on 5/5/2021, and as a condition of my bail bond, consent to the following. I understand that it is a violation of my bond to leave Colorado without the approval of the court and the surety that if I am arrested in another state, I can be returned to Colorado through the extradition process. I understand that I shall not be admitted to bail in any other state pending extradition to Colorado. I agree to waive any right I may have to contest my extradition, and I waive this right freely, voluntarily, and intelligently. Motion for prosecution to inventory discovery produced after June 2nd. Mr. Barry Morphew, by and through undersigned counsel, respectfully request that the court order the prosecution to produce a discovery inventory instead of the defense, and in support states the following. On August 6, 2021, pursuant to defense motions for sanctions, the defense was required to choose to conduct a discovery sanctions hearing, which would extend the completion of the preliminary hearing proof evident presumption grade hearing into November, or to proceed to the commence with the preliminary and proof evident presumption grade hearings on August 9th, 2021, without a ruling on the discovery motions. With discovery still pouring in, and while the defense prepares for this critical hearing, the defense will not know what is hidden in the discovery. When the hearings commence on August 9th, 2021, with Mr. Morphew being held without bond, it is unconscionable for Mr. Morphew to remain in jail for another 3 months due to the prosecution's misconduct. Mr. Morphew was forced to choose between his constitutional rights to due process, fair hearing, and effective assistance of counsel, and the right to bail. Mr. Morphew chose to proceed with the preliminary and proof evident presumption grade hearings on August 9th, 2021. On August 6, 2021, the court requested the defense provide the court with an inventory of the discovery. The defense agreed. However, upon reflection and review of the massive discovery, the defense contends this obligation should be on the prosecution, who has the ability to provide such an inventory to the court, as it is the discovery that they are producing, requiring the defense to index the prosecution haphazard, unorganized discovery, which is neither indexed nor contains file Bates stamps, places an undue and expensive burden on Mr. Morphew. The defense has a good faith belief that much of the late produced discovery was in possession of the prosecution prior to June 2nd, but produced in late July and August. This includes, but is not limited to, Sheila Oliver's Cellbrite download that was just produced a week ago in possession of the prosecution since July 2020, the 26 exhibits the FBI used in April 2020 interview with Mr. Morphew, and the CODIS DNA match exculpatory information that they've had in their possession, that's been in the possession of the prosecution since October 2020. The court has already found the prosecution has committed discovery violations requiring the prosecution, who should be able now to identify for the court and the defense the files, hard drive, disks, and paper discovery it has provided to the defense since June 2nd, 2021, is a more fair and cost-efficient solution. Mr. Morphew should not have to incur the cost of the prosecution's disorganization. Rule 16 and court-ordered violations. The defense asks that the prosecution have to identify the dates of the drives, disk, flash drives, and paper discovery were produced, which is contained in those devices or files. What, if anything, were duplicates previously provided on June 2nd, and the dates that those files, documents originated and were in possession of the prosecution. 5. The defense will supplement the prosecution's inventory if necessary after review. Wherefore, Mr. Morphew incorporates all prior motions and supplements to its motion for discovery, sanctions, and contempt, and respectfully requests the court order the prosecution to provide such an inventory described above by a date certain. Respectfully submitted the 7th day of August 2021. And just hold on, I've got to put my my watch on its charger, and I've just got to stop for a second because it's. Hold on 1 second. Okay. All right. So we are about 30 pages into the second part of this dump. But I will tell you that I am getting really disheartened by, doing, hey, Lisa, how are you? Everything went well. I was just thinking about you. That's good. You're all home and everything? My anemia is really bad, and so I feel like lightheaded, and I've got to take these, like, when you have this, you don't get enough oxygen, so you have to take these deep breaths. So it's just a lot to do this, and I don't know. I'm not really seeing that it's really wanted or needed based on the views, and that's just a sad thing. But I don't know. We'll see. We'll finish this one, and then I don't know. Just I don't understand. I really don't understand. Date filed August 20th, 2021. Motion to set bond and dismiss murder charges for lack of corpus delicti, proof evident, and probable cause D21. The hearing has confirmed that prosecutors lacking a body of crime additionally lack proof evident of probable cause. The brief, it discusses the requisite legal elements and the standard by which prosecutors must prove them. The court not only should set reasonable bond, but should dismiss murder charges because prosecutors cannot prove there was 1, a death of Suzanne Morphew, Suzanne, caused by criminal conduct of the defendant, Barry Morphew, Barry. 1, prosecutors must prove 1, Suzanne's death, 2, from criminal conduct, 3, of Barry. To establish guilt in a criminal case, the prosecution must prove the body of crime. Technically, the body of crime consists of 2 components, an injury and unlawful conduct causing that injury. In a homicide case, the body of crime means the first 2 of the 3 elements. First, the death. Second, the criminal agency of another as the cause. Third, the identity of the accused as the other. Only rarely is a body of crime an issue because typically there is a dead body with fatal wounds. When a body of crime is an issue, however, the difficulty is either that the victim, having similarly disappeared, no dead body can be produced, or that any death was caused by someone's foul play. Providing the body of crime does not invariably require a dead body, and murder convictions have been withheld where there is a confession, eyewitness testimony, or physical evidence that the victim was dead. The facts here, no dead body, no confession, and no eyewitness testimony or physical evidence of death, were held insufficient, even when a defendant with motive and opportunity had threatened to kill the victim. Okay, so let's just go, and we're not going to go through that case. Prosecutors have failed to provide a body of crime and Barry Morphew's guilt. Proof evident and probable cause must pass adversarial scrutiny. The two burdens of proof at this stage differ in degree. Proof evident requires more than probable cause, but share a procedural commonality. Unlike an arrest warrant, both must withstand adversarial scrutiny. First, to justify continued no-bond detention, prosecutors must show the proof is evident or the presumption great that the first-degree murder was committed by Barry Morphew. This burden of proof is greater than the probable cause, but less than the standard of beyond a reasonable doubt for conviction. In deciding whether prosecutors carried that burden, trial courts must resolve issues of weight and credibility. Second, and similarly, unlike one-sided warrants issued without adversarial testing, a preliminary hearing considers probable cause after an open and adversary hearing where the prosecution must establish that there is sufficient evidence supporting its charge. That hearing protects the accused by ensuring that the prosecution can at least sustain the burden of proving probable cause, specifically probable cause to believe that a crime was committed and that the defendant committed it. It acts as a screening device by testing the sufficiency of the prosecution's case before an impartial judge and weeding out the fatally weak case. This requires evidence sufficient to induce a person of ordinary prudence and caution to entertain a reasonable belief that the defendant committed the crimes charged. The trial court's fact-finding role differs in the two contexts. A proof-evident hearing resolves credibility issues and conflicting evidence, while a preliminary hearing resolves credibility only if the evidence